Hello everyone, welcome to Tarun IAS and very good morning to everyone. And this session is very important in the terms if you are talking about the prelims and as well as mains exam is concerned. So basically, current affairs is playing a vital role in your exam because it's lots of the topics has to be shuffled and going to be asked in the previous year and the upcoming years as well. So for this keeping in mind, we just need to think about what are the section is very important in terms of prelims and as well as mains exam. So going further to discussing about the article, like for example, a case for a more federal judiciary. So basically federalism, the questions has been asked in the last year also and this year as well. If you talk about GS paper 2 mains polity section, and if you talk about like federal judiciary, so basically federal judiciary, this will article related to Supreme Court and High Court tribunals. As we're aware about, if you have read Lakshmikant for the polity book, you have aware about the tribunals, collegium system as well. And for mains, we have to understand the centralizations of judicial challenges of federalism. So basically federalism is something like we can say like dividing the power between the state and a center, right? So it has to be enshrined in our Indian constitution. So basically dividing the power from a state to center, that is known to be a federalism, right? So it's a general term. The article is basically talking about and emphasizing on like the way forward, and in the case like in the like if you talk about like the article first emphasize the what is the issues of federalism and how it is started. So further moving, okay, so now we can say the article is focusing about nearly 150 years ago, A.V. Dicey wrote, the essential characteristic of federalism is the distribution of limited executive, legislative and judicial authority. As we know, the government organizations has to be a three forms, as we have studied. Like the first one is like legislature, like we can say in terms of India, that is the Indian Parliament, and second one is known to be a executive. So we have in parliamentary system of, we have adopted parliamentary systems. What does it mean, the word? Because see, if you are reading about the articles that are based on polity, try to focusing on more on words if your prelims is concerned, because sometimes the options, if you look at very carefully, only the one word has to be changed, right? So that is very like once you are solving the question, you are trapped in such kind of dilemma, like which one is the best option, right? Because it seems to be like either A or D is the right answer. But in that scenario, in the case of polity only, because sometimes they will change the data. If you talk about India is a parliamentary form of governance. So what does it mean, the word parliamentary form of governance? Which means that executive is responsible to legislature. Is that clear? So we can say that executive is responsible for legislature. That is known to be a parliamentary form of government that we have adopted in our country. So basically three forms like legislature, executive, and third one is known to be a judicial. Everyone having an independent role in terms of our Indian constitution. Like legislature having different role, executive have different role, and judiciary have a different role. Much has been written about the federal structure in relation to the legislature and the executive. India is a union of a state. Which article is talking about India is a union of a state? Article 1st of our Indian constitution, India, that is Bharat, shall be a union of states, right? So make sure that article 1 is talking about India, that is Bharat, shall be a union of a state, which has to be mentioned and enshrined in our Indian constitution. The Supreme Court of India has held that the federalist nature of our country is a part and parcel of the basic structure of constitution. It has not to be clearly mentioned in our Indian constitutions what exactly the basic structure, like, but it has mentioned in the Supreme Court judgment that India has held that the federalism nature of our country is part and parcel of the basic structure of the constitution. But is this the case for judiciary? And one is the important organs of the state. So it's the same thing that we are going to apply in the case of judiciary. So in this article we discussed more about these things. So before going further, that is the main question has been asked, that critically examine the Supreme Court judgment on National Judicial Appointment Committee, that is NJAC Act 2014, with reference to appointment of judges of higher judiciary in India. So that is a questions related to the earlier one. So starting from the inventing the basic structure doctrine. Doctrine is a basically term, it has been used in our polity books, that doctrine which means principle, right? So basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy, right? So make sure that judiciary played a highly proactive role in ensuring that India develops into a thriving democracy. In light of this statement, evaluating the role played by judicial activism, achieving the ideals of democracy. These questions already has been asked. Now, while going further, we have to understand first the nitty-gritty of the topics, which is here is judiciary. So federalism in judiciary. What exactly the term federalism according to our Indian constitution? Federalism is a midpoint between unitarianism, which has a supreme center to which the state are subordinate, and confederalism, wherein the state are supreme and the merely coordinated by a weak center. It means that we can simply, in a lucid language, we can understand that like the most of the power has been in the center and the most of the power is tilting towards center. So basically the idea which lies at the bottom of federalism is that each of the separate states should have approximately equal political rights. So make sure that basically, which means that each of the states should have approximately equal political rights and thereby able to maintain their non-dependent characteristic with the larger union. So an integral requirement of a federal state is that there be a robust federal judicial system, which means there should be a strong judicial system which can take and the right of the people and citizen of the people. So basically, robust federal judicial system, what they will do, they will interpret this constitution and therefore objectives upon the rights of federal units and the central unit between the citizens and these units. Federal judicial system comprises first the Supreme Court and then High Court, in the sense that it is the only these two courts which can adjudicate the rights. It means Supreme Court and High Court can save us in the case of the violation of fundamental rights. Dr. B.R. Ambedkar stated in the Constitution Assembly, because this quote is very important. While you are going to write some essay, this is very helpful in terms of mains exam is concerned, because B.R. Ambedkar, which is known to be a father of our Indian Constitution, so B.R. Ambedkar stated in the Constitution Assembly. So what is the difference, as you have mentioned, as you have written and read earlier, the written constitution, that we have written constitution, which means that is talking about and emphasizing that we have Constitution Assembly. So Constituent Assembly, which means that the B.R. Ambedkar mentioned the Indian Federation, though a dual polity, has no dual judiciary at all. And while you are talking about the federalism topic, you can quote it in the essay section and GS4 section and GS2. So it has mentioned the Indian Federation, though a dual polity, has no dual judiciary at all, because supreme body is the Supreme Court. The High Court and the Supreme Court forms one single integrated judiciary system, having jurisdiction and providing remedies in all cases arising under the constitutional law and civil law of in the state and as well as union. So basically, the word is going to be emphasized that the Indian Federation, though a dual polity, has no dual judiciary at all. So basically, whether Supreme Court and High Court are equal in status. So we have to understand, if you discussed the polity section, sometimes they will ask you the power of Supreme Court and as well as High Court. So Indian Constitution envisages the equality of power of High Court judges and Supreme Court judges, with the High Court judges not being a subordinate of Supreme Court judges. Make sure that this one, High Court judges is not a subordinate of a Supreme Court judges. Famous, the Chief Justice of the Bombay High Court, Justice M.C. Chagla, and the Chief Justice of Madras High Court. So when offered seats in the newly formed Supreme Court, rejected the offer, preferring to be Chief Justice of prestigious High Court than being ordinary judges in a newly formed court. The Supreme Court has on many occasions reiterated the position that Supreme Court is superior to the High Court only in the appellate sense. What does it mean? Appellate sense basically that while having some disputes that is have an international importance, in that case Supreme Court having a more power in the respect of High Courts. Therefore, the theoretical position has always been High Court judges and Supreme Court judges are equals. Basically, according to our Indian Constitution, High Court judges and Supreme Court judges are equal. A delicate balance between two courts existed from independence onwards until 1990s. Since then, however, it has been tilting in favor of the central court. So basically, the main supreme body in the case of judiciary system, that is a Supreme Court. So in this article, basically is the writer is going to emphasize that the need of the balance was underscored during the emergency when the High Courts. So significant number of pleas stood out as beacons of freedom. Even the Supreme Court failed in this duty. So basically, in recent years, three specific trends have greatly eroded the standing of High Courts. Which one this is? Leading to an imbalance in the federal structure of the judiciary. First, the Supreme Court, or rather a section of it just called the collegium system, because Supreme Court judges has to be appointed by the collegium system. So for the Supreme Court has the power to appoint judges and Chief Justice to the High Courts and the Supreme Courts. So basically Supreme Court has what the power of Supreme Court to appoint judges and Chief Justice to the High Court and then Supreme Court. And you know, in our country, till now, after the independence, since we are celebrating the Azadi Ka Amrit Mahotsav, but still despite having this, since once we got freedom until now, we do not have women CGI, which is Chief Justice of India. So basically, so we have, in the case of women empowerment, you can quote it somewhere. So this collegium has the power to transfer judges, which Supreme Court judges. Collegium has the power to transfer judges and Chief Justice from one court to another. Second one, successive governance has passed law and create parallel judicial system of courts and as well as tribunals. Basically, tribunals and courts have a huge difference, because tribunals has a, we can say, as a kind of as a kind of like temporary court, we can say. So tribunal which provide for direct appeals to the Supreme Court bypassing the High Courts. So in that case, the most of the power is tilting towards Supreme Court. Third is the Supreme Court has been liberal in entertaining cases pertaining to trifling matters. Trifling matters is that for those matters which have not exactly mentioned in the Constitution. So basically, first one is that federal system having the appointing of judges. So in short, we can say the appointment of judges has to be held by Supreme Court. And what about the second one is that parallel judicial system and tribunals which provide direct appeals to the Supreme Court by passing the High Court. That is the second one. And third one is that Supreme Court has been liberal in entertaining cases pertaining to trifling matters. So basically, Now we got to know is that now what are the issues of centralization of judiciary? What exactly the issues of centralization of judiciary? Centralized ruling, this has inevitably led to the balance tipping in favor of centralization of the judiciary. The greater of degree of centralization of the judiciary, the weaker of federal structure. Which means that we can say the greater degree of centralization, more centralization, we can say that if you're talking about like before 1991, there was license Raj, right? So before 1991, like why I'm talking about there was license Raj, if you have read the NCRT very well, so you got to know it has mentioned before 1991 there was, because after 1991 there was LPG reforms, that means liberalization, privatization and globalization, which means we opened our economy. So basically before 1991, so there was a license Raj, it means more power have centers. It means that a person who want to establish a factory somewhere, it has to be almost take like 1 year, more than 1 year to solving all the documentations, right? So government has abolished this system, has to be some system that not should be a license Raj system. So government have permits to do some less documents and like we can say similar to like a e-governance structure. So basically centralized judiciary more in interest of the center. In the United States, empirical research by the legal researchers show that US Supreme Court is far more likely to strike down a state statutes as unconstitutional than a federal statutes. So this research leads to the conclusion that judicial review by a centralized judiciary tends towards unitarism, which is unitarism, which means the opposite of federalism, right? So which means that one power is in the case of USA, which have what empirical, as it has mentioned that you can see it here, like a state have a more power. So like in Nigeria, similar federal country, it has to be mentioned that the Supreme Court favors the jurisdiction of the central government over the state units, and this has manifested itself in recent litigation over mineral rights and subsoil rights, where the Supreme Court has favored interpretation which supports the rights of the center over the states. It means that maximum rights has to be given to the center and minimum power has to be given to the states. Now further moving, if you can say, like interference of Supreme Court in matters of local importance. So in the term, if you talk about the local importance and aggressively intervention, Supreme Court leads many to approach it directly as a panacea for all its befalling the nation. Panacea, which means having the all solutions have. So in 2018, some individuals from Delhi directly filed a petition in the Supreme Court to curtail, like we can see this one. This Diwali celebration is counted in what? So the Supreme Court, like frivolous matter. So frivolous matters is what? That matters, for example, there is a parking stand is there and there is a dispute between two person, like कि मैं अपनी bike ही खड़ूंगा, that is a kind of things. That has to be dispute. It had not mentioned like what kind of punishment you will give. It has not mentioned in our Indian Constitution and as well as IPC section. So that matter is counted to be known to be a frivolous matters. So like someone is not violating the rules of government, like in Diwali celebration. That kind of matter is not exactly mentioned in our Indian Constitution. That known to be a frivolous matters. The Supreme Court interference in the matter which are clearly to local importance, having no constitutional ramifications. The Supreme Court itself recently frivolous matter, which means the word frivolous is applied to things that do not deserve serious attention, are making the institution dysfunctional. So basically these matters waste important time of the court, which could have been spent on serious matters, pan-India matters. So basically as we know that the lots of cases has been pending. So Supreme Court and High Court is resolving that case. But if the lots of frivolous matters has been issued, then how it possible the burden, like less the burden of the courts, more the judicial system will be strengthened. So basically, the creation of parallel hierarchies of courts and tribunals, whether it be the competition commission or the company law tribunals or the consumer courts, all these cases the high courts are bypassed. Laws has been drafted such that high court has no role to play and Supreme Court directly act as a supreme body. So basically the hierarchy is going to be a, if we talk about like competition commission of India, if we talk about the company law tribunals and as well as consumer courts, all the sections is going to be a, like if any dispute has been occurred, the case goes to the Supreme Court only. So that has the power has been discussed. Further moving, so now what can be the way forward? The Supreme Court should itself, now way forward we can mention in the conclusion part where like introduction, body and conclusion, if the any topic had to be asked about like judiciary and federalism, so we can quote it there, like what should be the way forward. The Supreme Court should itself recognize the importance of self-abnegations and restore the federal balance by re-empowering the high courts. It means if there is a similar power has to be given to the high courts as well, so in that scenario the burden of Supreme Court has to be reduced and the more judicial system will be strengthened as well. So this will be the best interest of the nation. The Supreme Court was created under the Constitution and is a relatively new court. On the other hand, some of the high courts in our country have been existent since the 1860 and some existed even before that in their earlier avatars as Supreme Courts of the presidencies. It is advisable that their roles should not be minimized even unintentionally. A delicate balance is required to be maintained between the Supreme Court and the High Court in order for the constitutional structure dreamed by B.R. Ambedkar to work. So basically, in short, we can say the outcome of this article is that the Supreme Court has to be given power to the High Court, and this will be in the best interest of the nation. So what is the importance of this article? So once you are going to write any essay, you can quote it over there. So because in the if we need to strengthen our judicial system, we need to take some kind of steps.